Next lesson is general exceptions. This is from the section 76 to 106. The general exception from that first is the mistake of a fact. Means because of the mistake of the fact the act was committed. So it is from the section 76 and 79. Act done by a person who is bound or by the mistake of the fact believes himself bound by the law. This is section 76. Means it lays down that nothing is an offense which is done by the person who, owning to a mistake of a fact and not a mistake of a law, in a good faith believes himself to be bound by the law to do that act. Means the offense which is committed by the person because of the mistake of a fact will be not considered as an offense, as that act has been done in a good faith and believes himself to be bound by the law to do so. But if it is by the mistake of a law, then it will be considered as an offense. Mistake of a law. So it is to be remembered that the mistake of a law is no defense, but a mistake of a fact is, means only the mistake of the fact will be considered as a defense. Mistake of a law is no defense. Everybody is born to know the law of the land, and ignorance of a law is no excuse. When mistake of a fact is a no defense, it is a no defense if the act itself is illegal. Means when the act itself is illegal, that time the mistake of a fact will be not considered as a defense. This is the first general defense, that is the mistake of a fact. It says that when the offense which is done by the person owning to the mistake of a fact, and when he does that act in a good faith and believes himself to be bound by the law to do so, then only he will be not considered as a offender. But if he has done that act due to the mistake of the law, then it will be considered as an offense.